Welcome, everyone, to this presentation on an update to the brand new contingency to contract and closed form for the Bluegrass Realtors. My name is John Rumpf, and I'm an attorney at the law firm of White, McCann, and Stewart. I've had the privilege of working with the Forms Committee and the Board of Directors to update the previously released version of this form that I'm now excited to share with you here today. Let me begin with a disclaimer by letting you know that neither this form nor this presentation are intended to be legal or tax advice regarding any particular situation or transaction. I would encourage anyone who's watching this video or relying upon the information in this form to consult independent professionals about any specific questions they may have about a specific transaction they are dealing with and how this form may impact that transaction, either for tax purposes or for legal purposes. I would add to that, although I am the legal counsel for the Bluegrass Realtors, I cannot give any individual agent advice regarding a specific transaction and how this form may interrelate to that transaction. And I would encourage you to consult independent legal advice regarding same. As everyone is aware, this is the second iteration of this brand new form, and it's going to replace our existing Kickout form that was just released. We were really aiming at preventing having new release forms. However, we received quite a bit of feedback about the need to expand the options within this form. And the Board of Directors and the Forms Committee, having listened to that, we've kind of added one more option for parties to negotiate how to resolve and deal with this situation. And so this form expands upon the prior form. I would, as an overriding theme of today's presentation, tell everyone that this is a huge change, not necessarily in the way we practice, but in the forms that we utilize related to issues surrounding a buyer's need to have a contingency. And I would really, really encourage everyone to think of this form as a tool and think of it as a resource for them that they need to familiarize themselves with well in advance of ever having to use the form. I believe that this can be a really powerful tool for our membership and provides a lot of solutions on how best to address situations when a buyer wants to purchase a piece of property, but wants to do so contingent on selling another piece of property. And I think this form tremendously improves the party's options for that, but it will take you a little while to become familiar with how to best utilize it for your clients and your needs. I think it's been common practice prior to the release of this form to use a number of different forms, and really we're just trying to streamline that process and provide you, again, a better tool to utilize when this situation pops up in your transactions. With that said, I'm going to kind of jump into some nitty-gritty details. I will kind of, as an overview, let you know that this form cannot possibly address every potential scenario, nor every set of facts that you may want to negotiate to between yourself, whether you're representing a buyer or a seller. It's intended to provide some options to kind of streamline and create some presumptions about how the process is going to play out, but you are not going to have a form that's going to deal with every potential situation. Myself and the Forms Committee and the Board of Directors really have tried to create a tool, but it probably won't be perfect for every situation. It's aimed at addressing kind of the normal transactions that occur in our marketplace and providing a tool that can be best utilized in those situations. The next thing that I will say is that it is really, really important to understand kind of how all of these sections interrelate with one another and how they affect one another. And so I think holistically, to understand kind of this form generally, you do need to keep in mind that we are dealing with two separate contingencies when this form is being utilized. We're dealing with the buyer's contingency to get their current home under contract, but we're also dealing with a separate contingency for them to close on that contract if they're able to. The prior iteration of this form kind of created those two things, but it did create a presumption about the survival of the buyer's contingency to close on their contract. And we're going to add a new option that kind of removes that from the process. So this form, I think, provides an additional option for the parties. And it's based, again, on a tremendous amount of feedback that we've received. And we're really attempting to provide a tool that can be utilized in the marketplace very, very commonly. This was not done lightly. We've done this and looking at how folks in different jurisdictions, other MLSs or associations, how they handle this situation. And we've also taken into consideration your all's feedback, like I said. So Your experience in the marketplace kind of dictates what the norms are. And we are trying to create forms that, again, align with the values of our members and provide a tool and a resource to them. I would say to you, we are going to really, really try not to make changes to forms throughout the years, but the decision to update this form came really based just upon the significant feedback that we have received. Our hope is, again, that this will provide a tool to streamline the process and not create a sense of anxiety or unnecessary difficulty for agents or their brokers. Again, the first section that I'm going to highlight here at the top is two things. One, the naming of this form, and this was done intentionally, and I talked about this in a prior iteration of this presentation, but the name of this form is lengthy, but we're recognizing two things. Really, the intent to emphasize that there's two separate contingencies, which is really our kind of new terminology, that we've got this contingency to get a contract and also the contingency to close on that contract. But we didn't want to completely abandon kind of the common language that has been utilized historically within our marketplace, and that's referring to this situation as a kickout. And so we have kept that in the name as well. The second thing that I would highlight is, again, a disclaimer. I think it's important every time you're addressing a form with a consumer for them to be reminded that they need to consult with a tax professional and a lawyer of their own choosing related to the form. All of our forms have significant tax and legal consequences for consumers, and it's really, really important to address that with them every time that you're representing someone, to make sure that they are informed about the potential impacts on their situation and that they're getting the advice from competent individuals. The next section I want to highlight, and although it kind of appears to be just boilerplate language, it's actually quite legally significant. And people, consumers, agents, everyone needs to understand its impact on this form. The form is intended to be used as a contingency form to the contract. It's not intended to be used as a standalone agreement, and it's intended to relate back to the contract. For that reason, as was the prior practice, you need to identify the contract that it's an addendum to. You need to identify the property address of that contract and also the contract number. And we're also going to do a third thing here, and that is we want to identify the buyer's property that has to be sold. The purpose of this contingency is, again, to give buyers the option to get under contract and still have the right to contract to sell their property and potentially to close on that contract. We need to specifically identify the property there that the buyer has to sell. The other thing that we're doing, and these are the legally significant things to draw your attention to, is one, we're making sure that the definitions in this form are all the same as in the contract. So capitalized words within this form are intended to take on the same meaning as that in the contract. If you've watched my other presentations, one of our goals is that as we go through and update our forms, that we get to a point where we have a standard set of definitions for all forms so that consumers and agents, everyone who's involved in the process, will know what our words mean in all of our forms. The second thing that I would highlight for you is that this form makes it very, very clear, and I'm looking at lines 6 and 7, that time is of the essence as it relates to the deadline set forth in this form. And also, this is very, very important, is that all deadlines in the contract should relate to the effective date of the contract, except as provided in this form. This is a change from the original release of this. There's going to be one section where the deadlines are altered, but the basic gist is that the deadlines in the contract are going to remain in place. And it's very, very important for us to understand that, because I think one change that will be for some people is how they relate this addendum to the due diligence period for buyers. And unless Section 3A is chosen, and we're going to talk about that down below, but unless that is the option selected by the parties, the deadlines for due diligence are going to be the deadlines set forth in the contract, unless the parties agree otherwise. And so the contract deadlines are going to remain in effect unless the parties agree to do an addendum to change those deadlines. And that's a very, very important thing as you educate yourself and your consumer about this form. Practically speaking, that has significant implications, because a buyer may have to begin due diligence, sooner in the process than when they know that this contingency has been released. And so it's just really, really important to see the interplay between the sections and understanding that your buyer may be, under a very short period of time to do their due diligence, even though this contingency remains in place. The next thing to understand is that, this form isn't intended to alter anything in the contract. The goal is to keep the contract the primary piece, and that these addendums are not going to alter it. The next thing that I kind of point out to you, and this is drawing your attention to line number 12, and that is that it makes it explicitly clear that while this contingency to contract for sale and the contingency for closing is in effect, the seller may continue to market the property. I don't think that that's a change. I think that's everyone's general understanding, but I did want to point out to you that it's made explicit in this new form. The next thing that I'm going to point out to you is the first step in this process. Parties agree we're going to allow for the contingency, but we want to make sure that the buyer's property is either already on the market or is going to be on the market by date definite. So this is specifying, a very, very specific time frame for the buyer to get their property listed. And the idea is we want to make sure that sellers are able to confirm who the property is listed with, and also, that the deadline is short enough. Probably the parties are going to negotiate to where the seller feels comfortable that we're moving forward in the process. And really, the purpose here is to make sure that everyone has the opportunity to negotiate this deadline, and that it is explicitly set forth and defined by this agreement. The second section is setting forth a very specific deadline for the first contingency, which is the buyer getting a contract for the sale of their property. Again, the first contingency is about the buyer getting a contract. The second contingency on this form is the buyer closing on that contract. So if you're looking at this form, I think it flows in a kind of common sense way. Part 1, we have to get the property listed. Part 2, paragraph 2 here, we're talking about a deadline for when the property is going to be under contract for sale. And the purpose of this is to very specifically set that deadline as kind of the end date for when the buyer has to have their property under contract. If they do not have it under contract by that time, and this deadline is not extended by a mutual agreement of the parties, then the parties are going to sign a release of the contract, and the escrow is going to be returned to the buyer. This is creating a window of time for the buyer to obtain a contract, and the seller to know the date definite by which this needs to occur. This is important because all of the other deadlines in this agreement and this addendum really flow from this date, and they all interrelate with this date. So it's very, very important as you familiarize with this form to recognize that the date selected here in section 2 on line 22 is going to have implications for the remainder of the agreement, and it's going to interplay with the other choices you may make. This is done intentionally to give some freedom to negotiate and to give agents an ability to understand how, by selecting different time periods for when this contingency to contract to sell is released, how that will implicate other parts of the contract and the rights and responsibilities of the parties. And so it's really, really important for you to familiarize yourself with the form and to think about the ways that this date impacts the other sections. Section 3 is really then talking about what is going to happen prior to that deadline. So buyer and seller agree in section 2 that the buyer is going to have until a certain date in order to get its property under contract to be sold. Section 3 talks about what can happen during that period of time. So up and to the point where that deadline occurs. And option A, which is highlighted here on the screen for you in lines 25 through 35 of the form, is what I'm going to call the immediate kickout. I think that's how it's been referred to historically in our marketplace. And this is a situation where, yes, the seller agrees to a contract with the buyer, and it allows it to be made contingent on the buyer selling other property. But the seller says, I'm going to have the right to immediately kick out your contract in the event I receive another offer that does not contain a contingency for a contract. And we've really tried to make this very explicit that if a seller obtains what I'm going to call an offer, that doesn't have a contingency for the buyer in that new offer to sell their existing property, then they can immediately kick out this contract. I would say this is obviously the most seller favorable position. It allows for a buyer and a seller essentially to reach an agreement on terms as to the purchase and sale of property, and for the buyer to have some period of time that's set forth in paragraph 2, whether it's 24 hours, 3 days, 7 days, 2 weeks, whatever, to obtain a contract to sell their property. And if they don't do that, the contract is void. But during that time, the seller can immediately kick you out if they have another offer, during that period of time. And I think there's two really important things to highlight here. And that is that if Section 3A is chosen by the parties, is if this is what they negotiate, then the buyer does not have to do any due diligence until the contract to sell deadline passes. And I think this is a really important thing to understand. And again, two really important things to highlight here are that if this selection is made, the buyer does not have to do any due diligence until the contingency to contract deadline set forth in line 22 passes. And I would highlight for you, this is the only circumstances where the deadlines in the contract are not going to apply. So this is the only time where there's going to be an automatic extension of the due diligence period. And it's really, really important to understand because I do think it's common for some people to not start due diligence until the contingency period is either satisfied or passes, and that this is the only selection the parties can make where that deadline is automatically extended. And this decision was made because until that deadline passes, the seller has the right to kick the buyer out if the seller received that offer does not have this contingency to get a contract. And that would be the case even if the buyer has obtained a contract. So the buyer gets a contract prior to the deadline, but the buyer's contract, again, is going to be preserving the right to close on that contract. So if the seller is able to receive that clean offer, then it creates a situation where buyer could have started due diligence and seller has the right to kick them out. And so we wanted to create some equity in this form that allowed basically a buyer not to have to assume the risk of beginning in the inspections, maybe having an appraisal done and paying those costs if there was still a chance the seller could kick them out with the immediate kick out. So that's the reason why that was chosen. And the second thing that I'd highlight is the seller's right to an immediate kick out expires on the deadline set forth in line 22. So the parties have the freedom essentially to negotiate a situation where, depending on the circumstances, that deadline may be very long, it may be very short, but the parties understand that until that deadline, buyer doesn't have to do due diligence and seller has this immediate kick out. So there's incentives for the parties to reach an agreement. The longer that is, the seller's right to maintain the kick out exists, but the buyer doesn't have to do due diligence. So the parties can work together to negotiate an agreement that best meets their circumstances. And as you work through this form, you really realize that the interplay between the deadline selected in line 22 and the rest of the form really creates a lot of different scenarios for the parties to negotiate. Our intent with these forms is to allow the freedom to negotiate, but to put guardrails so that we have norms within our marketplace that everyone operates within. Option B, which on the form is going to be in lines 36 through 48, is essentially, creating a situation where buyer and seller want to agree that, yes, the seller is going to continue to market the property. Yes, the buyer is going to continue using their best efforts to get their other property under contract, but by the contingency, the contract to sell deadline. However, if a seller is able to get another offer that is not contingent on obtaining a contract to sell their property, during that window of time, the seller is going to give notice of that offer to the buyer, and the amount of notice is left blank, so the parties can negotiate that. But they're going to have to give that notice, and then the buyer is going to have to release both the contingency to get a contract and the contingency to close on that contract. So this is the new selection within the form. Previously, we In the notice provision, there was this kind of presumption the buyer would retain the right to close unless they explicitly chose not to. Here, we're creating an option where buyer is going to release both of those contingencies. And I think this option is more neutral than option A, which is really, really seller friendly, but it remains seller friendly here in B, as it requires only that they have to obtain an offer that does not have a contingency to contract, and it requires then the buyer to release both of the contingencies to get a contract and the contingency to close by executing the appropriate sections within the form. And so this allows for a situation where buyer may want to accept the contract, but they want the freedom that if they get an offer, another contract offer, that they can go ahead and close on that, without having to wait for the buyer to close on their contract, if that makes sense. So creating another option here within this marketplace that's pretty common. The next section, option C, is still relatively neutral, but I think begins to lean in favor of a buyer in terms of how this contingency form will be utilized. Based upon kind of information that the forms committees receive, the board of directors, and just knowledge of realtors within the marketplace, this seems to be the most common practice and how a kickout situation typically applies for our members. And the purpose of this section is to allow for a situation where the prospective buyer has a period of time following notice from the seller that the seller has received an offer that contains, does not have these contingencies in it, and they want to be able to accept that clean offer, again, containing neither the contingency to get a contract or the contingency to close on that contract. And they are going to give the buyer notice of their intent to accept that unless the buyer is willing to remove the contingency to contract. And so this is a situation where a notice is given and the buyer would only remove the contingency to get a contract, but would still be able to retain the right to actually close on that sale. And so again, I think this is a very common occurrence in our marketplace where seller wants to have a kick out with notice, buyer wants to have the ability to say, okay, we've received your notice. We're going to make whatever efforts are necessary within that notice provision to get our property under contract, but we still want to have the ability to close on that contract. And I think, that's very, very common where a buyer, maybe their financing is dependent on being able to sell their existing property. Maybe they need the proceeds from that sale for their down payment. But this creates a situation where buyer is able to get a contract quickly within that notice period and remove this contingency, but maintain that contingency to sale, or excuse me, to close on that sale. And again, I think this is very common. You can see B and C are somewhat similar to one another in the sense that both require a seller to give notice of their intent to accept the other contract, and both give the buyer rights upon receipt of that notice. B requires the buyer to release both contingencies. C simply requires them to get a contract and release only the contingency to close on that contract. Again, I can't emphasize enough that the timelines that the parties negotiate within B and C are going to be very, very important in determining how favorable each of those contingencies are to either the buyer or the seller. Both B and C, and the way they can play out in the marketplace with the freedom to negotiate between the parties, can provide for relatively neutral outcomes for the parties as it relates to this kickout. And I think allow for a balanced approach in negotiating, and also for the ability for parties to get the outcomes that they want at the front end, and to have clarity about what rights each of the parties has as the kickout process plays out. And again, I would just emphasize that when you select B, you're going to be releasing both contingencies. When you select C, the seller, if they're able to get the contract, is only going to be releasing the first of the two contingencies, the contingency to contract to sell. And I think, my understanding from the feedback we received is the disputes related to kickout situations most of the time centered around not the parties not having the same idea of what the release of the contingency to contract to sell, what impact that had on the transaction. Some folks would think that they still had the contingency to close on that contract. Others would take the position that no, it was only one contingency. And so really that's the primary issue that we're attempting to resolve with this form, is making sure that there's clarity around that situation, really so that from the front end, both buyer and seller consumers are aware how the process is going to play out, and everyone understands what their rights are going to be as we move through this process. And again, I'll just emphasize that when you select 3C, even though there's a release of the contingency to the contract will still have to close, and our primary contract is going to remain contingent on that secondary contract closing. I'm sure all of you have dealt with this, and it's something that swings when the pendulum of the market swings. But right now, we're in a situation where it's pretty common to have purchase contracts that are contingent on the sale of other property. And as I'm sure some of you know, a lot of times these closings may be stacked up upon one another. So it's just really, really important for consumers to have a good understanding of how this is going to play out in their situation. The fourth option here in paragraph 3 essentially creates a situation where the seller does not have the right to cancel prior to the contingency to contract to sell deadline. And this is really not a kick out at all. This is a situation where the buyer and the seller agree that we're going to allow for this contingency to get a contract, and we're not going to allow the seller to terminate that at any point in time prior to the deadline, again, set forth up in section 2. So again, there's an interplay between the sections. I envision this may be utilized in circumstances where the seller wants to agree to a contract with the prospective buyer, and they only want to give them a short window of time where the buyer is going to have the opportunity to sell their property. Maybe it's a really competitive market. They know, based on the buyer's information they relayed to them in negotiations, the buyer's already had a lot of interest. Maybe they got offers that they're considering. So they want to allow to have a contract and give the buyer a very short window of time to get their property under contract. I don't imagine this will be the most common selection between the parties, but I do think it allows for a very streamlined process that's pretty straightforward, that parties can utilize to set terms of their deal, maybe while a prospective buyer is negotiating with buyers of their property. So in a situation where, maybe buyers had an open house, they've got 3 or 4 offers on their property, and they're just trying to figure out which is the best one to make, and simultaneously they're trying to purchase something else. So I think, again, this is something that comes up pretty regularly enough that we wanted to include an option for the parties to have, because I do think it allows really a situation where it's very, very, very a streamlined process, and probably simplifies this situation the most, and allows really a streamlined process that doesn't get into all the notice requirements of the kickout. So again, I wouldn't consider option D a kickout. I would consider it more just a straightforward contingency to get a contract, which again, if you select D, it's only going to be the contingency to contract to sell that's going to get released. You're still going to have the contingency to close on that. So keep that in mind as you work your way through this form. Moving on, really the next section here, paragraph 4, is talking about when the buyer is going to release the contingency to contract for sale. And again, this would only be releasing the first of the 2 contingencies. The second contingency to close on that contract is going to remain unless it has been removed by another provision or the parties kind of voluntarily elect to do that. So this is talking about simply releasing one of the 2 contingencies, and that would be done pursuant to section 2 if the time period passes, or pursuant to sections 3B or 3C if those choices were utilized and the buyer has to release this contingency to get a contract. If they don't do that, obviously the time's going to lapse because they haven't gotten their contract, and the deadline set forth above in paragraph 2 is going to pass. So again, you'll see when you flow through the signature section how this is going to play out, but this is the first release of the 2 contingencies that will occur. Kind of moving on here, the next section, section 5, is creating, and this is new, I think, in terms of the marketplace, but I think everyone will understand the reason for its being included in this, and that is that we're going to create a date definite by which the parties are going to agree they're going to close regardless of these contingencies. So what we're talking about here is, again, the situation where it's, maybe this has been the case over the last year or so, where you might have 3, 4, 5 closings stacked up on top of one another, and all of them are dependent upon another, the prior contract closing. And you're in a situation where parties would like to have a date definite for closing. Another time that this maybe comes up is, we had a contingent situation where the federal government's closed. So certain types of financing is not able to close while the federal government's closed. And, and your sale is contingent on the buyer of another property who's got that type of financing being able to close. And so what we are doing is to try to establish a situation. The first contingency is gone. They've got a contract to sell, the buyer does, but they got to close on that. And we're going to set a deadline, an absolute closing deadline by which that contract has to close, or our contract can be terminated and made void. And I think it's important because otherwise you can get into the situation where we don't have a date definite for closing. And again, I would emphasize this is going to interplay with your contract. So you can have the closing date in your contract, and the dates can be the same. But this is a closing deadline. It's not the closing date. So the closing date in the contract, again, time is not of the essence unless you've explicitly made it so. So closing dates, in our marketplace are routinely extended for whatever reason. This would be a definite deadline. So you may choose to make this closing deadline in the contingency form a different date. But the closing date in the contract, again, is taking priority and would have to be extended to mirror this if you got to that situation. So I can see where there could be confusion surrounding this issue. And I really, again, encourage you, if you're not going to make those dates the same, to understand how the forms interrelate with one another, particularly the PSA, as it relates to this addendum. I think it's going to be the best practice to, figure out how you want to set these deadlines based upon the other transactions that are involved in your transaction. And what I mean by that is the number of transactions stacked up on one another, when their closing dates are. And I think it's going to be very important to have conversations with the consumer on the front end so that everyone's on the same page about when this drop kind of dead deadline is going to be. So there's no confusion about it later on. I do think this is necessary because sellers need to have, a time period which they know they're going to close, because when they're presenting, the situation into their own decision making, they need to understand, hey, I know I'm going to close by XYZ date. So this allows for that without making the contract itself, to make time is of the essence with regards to closing, and allow it to take place within this contingency. I also, kind of want to point out that in this paragraph 5, you could have had a release of the contingency to close already. And I think that's pretty straightforward. But if you selected 3B up above, the buyer will have already released both contingencies at the time that they received notice from the seller and they were required to release both. So at that point, they're going to have already released this contingency, and the deadline set forth up in section 3B above is what's going to take place with related to closing and as it relates to the contract itself. But I did want to highlight that to you. Kind of moving on, and it's a little unusual, but I do want to go over here the actual execution sections of this, because I think it helps really to understand the form and how the execution is going to take place. So the first signature block here is where we're going to really effectuate this addendum, this contingency addendum. And this is talking about, getting both of these contingencies set into place. So this is where the buyer and the seller are going to execute this at the same time, more than likely. I guess it wouldn't have to be, but likely at the same time that they execute the purchase agreement. And, it's going to be a best practice to do those things simultaneously. Consumers are aware. And again, this is designed to interplay with the contract itself. The next signature section here, starting in line 81, this is talking about basically the seller's cancellation of the contract pursuant to section 3A. And if you recall, section 3A is the immediate kickout. So this section will be utilized, top section here, lines 72 through 80 have been executed. We've got these contingencies in place. And seller, this is their mechanism for providing notice to the buyer of their cancellation of the contract pursuant to section 3A. So parties have selected 3A, and the seller is going to void it based upon their right for the immediate kickout. The next section here, this is talking about the removal of the contract for sale contingency. So the first of the two contingencies, this situation is going to apply where, either the deadline's passing and the buyer has to remove it, or, the options selected above cause the buyer to have to remove the contingency for contract for sale. So It could take place in a number of ways. Either paragraph 2 is there, or the options selected by the parties in paragraph 3 are going to come into play, and buyer has to remove only that contingency to get a contract. Again, you execute this section, the contingency related to the contract for closing on that is still going to remain in effect, and that is only going to be executed here when this last section, which is lines 99 through 105, is the removal of the closing contingency. This will be executed by the parties only if they're removing that closing contingency. That's going to take place in the limited circumstances, I think, where 3B is the choice, or when you're at the closing table and they're finally, they just closed on that transaction shortly beforehand. Your closings are stacked up upon one another, and they are releasing it as they close your transaction. I think that's a pretty self-evident way it's going to play out, but it's something that won't be executed until I think the parties are actually at closing. Again, I think to understand the overall purpose of this form, you have to think of it as a big change, and you have to think of it as two contingencies. I think it's been difficult in our marketplace previously, having buyers and sellers and their agents not really on the same page as to whether or not the kickout situation was creating one or two contingencies. I think this form helps to make it explicitly clear. And I think we've now given the parties enough options to where they can self-select and negotiate for what outcomes they really want when these circumstances arise. I'll be the first to tell you that I don't believe this form, or any form for that matter, could be a toolkit to deal with any potential situation. But this is at least creating four choices. And it is also creating the ability to negotiate within those choices, which really creates almost an unlimited number of ways that this form can play itself out. Because of that, I think we've accomplished the goal of having, preserving the parties' rights to negotiate. But I do think it puts an onus on agents to really familiarize themselves with this form so that they really understand it forwards and backwards. I think it's important that you're doing that well in advance so that, the first time you're looking at this in depth is not when you're presenting it to your client, if you're the listing agent and you've received it as an offer, or if you're the buyer's agent and, you're having to come up with an offer that you want to have be contingent. I don't think you want to be looking at this for the first time then. I think it takes, reading it carefully, looking through the signature section, and really understanding how it interrelates with one another. And I would encourage you to do that. Give yourself some time and come back and look at it again, because I think it's a very good form, but I think it is complicated in the way it can be utilized from a negotiation standpoint. And I think it requires a lot of learning. I know the association, Bluegrass Realtors, is going to put out not only this video, but some training opportunities for you to ask questions. And I would really, really encourage you to familiarize yourself with it on the front end, educate yourself on how best to use it for your clients so that you're prepared when the time comes and you need to utilize it. As always, I appreciate your time. I wish you the best of luck in your endeavors this year and a lot of success at our current marketplace. Thank you.